As you're getting entered into the session, we're going to start in about a minute. I'm just going to speak so you all can have a chance to set your audio levels, make sure that I'm not too loud or too quiet. Thank you as you're coming in. I can see we've probably got about maybe half of everybody in, and we'll just, again, we'll just give it another maybe 40 seconds until we start. Excellent, and thank you all for joining us. I know we have attendees from China and from different parts of Asia and the Middle East and Europe and certainly America. So we hit, and Africa too, actually. So we hit a pretty broad audience, which is always great. It's really important that, you know, we remember that this is a global economy and this isn't just a US and China problem. This is something that needs to be considered and talked about for everyone. So I'm so glad that we have such a broad representation here. All right, and I'll give it about another 30 seconds and then we'll get started. So looks like maybe about half to 2/3 are signed in now. And this is also the funnest part of the webinar, when I get to sit here and talk and I don't have anything to say, so I get to make up a whole bunch of stuff as I go. Perfect. All right, well, I think pretty much everybody's in, so I vote we just get started. So hi, everyone. Welcome to Trade Finance Compliance Challenges with the China's new export control law. We are just thrilled to be joined by an incredible group of experts. Our panelists are just spectacular in this area. Their knowledge is really second to none, and we are just so grateful to have them joining us. What I'm going to do is I'm going to just walk through a couple of quick housekeeping points, and then I'm going to introduce the moderator today and today's panelists, and then I'm going to hand it over and let them do it, because I promise you don't want to hear me babbling anymore. So first things first, anyone who's joining and looking for CPD points, this is worth 1 CPD point for anyone with CDCS or CTFC or any of the other banking qualifications. If you reach out to me afterwards, you all should have my email, but it's MBYRNE, just like my name, at IIBLP.org. I can send you the certificate that you can use to get your credits. Certainly, unlike a real live meeting, there's no, normally I'd be saying, well, the bathroom's over there and the water's over there. But certainly in this live session, you all can, find your own stuff in the house. It's only an hour, so hopefully, hopefully you don't need to do any of that stuff. I have my coffee here that I'll be taking advantage of as soon as I get to mute. So, really the biggest housekeeping issues are if you have a question or a comment for the panelists, straight down there is is chat and Q&A. You can use either. If you just have a quick note, the chat's fine. My suggestion, though, is that you use the Q&A feature. It lets us track the questions better. So that would be our preferred method of receiving questions. Let's see. Oh, yes, of course. All of our panelists are here speaking for themselves. They are not speaking on behalf of their organizations or company. So I just want to make sure that everybody knows this is their own personal opinions, which is really, make sure we keep that straight. Excuse me. We will also be recording this, so the recording of this will be available, probably about an hour afterwards. And you all will get an email with a link to be able to watch it. You can share it with your colleagues and all that good stuff. So with that, why don't I just introduce our introduce our moderator and our panelists. So first, our moderator is Adam Klauder. Adam is the Senior Director at Guidehouse. Andrew Jacobson, Andrew's an associate at Seward and Kissel. Rachel Alpert is a partner at Jenner and Block. Sally Peng, Sally is the Managing Director at FTI Consulting. And last but not least, Soh Chee Seng is the Technical Advisor to the Association of Banks in Singapore. This is really just an excellent panel, and I'm so excited to hear what you all have to say. So Adam, without further ado, let me hand it over to you. And if you need me, I will be here in the background, not missing a word.
Great, thank you, Michael. And I want to thank you and the Institute of International Banking Law and Practice for putting together this panel. We've got a great webinar today on China's new export control law. It was passed back in October of last year and went into effect on December 1st. And it's China's first comprehensive export control legislation. It's part of a broader effort by China to build out its national security authorities, and at first blush appears to be a reaction to some of the restrictions that have been imposed by the US and other countries on China's access to sensitive technology. There's a lot of questions about how this law will be applied, whom it will target, and the extent to which it will impact banks and companies both inside and outside of China. Today, we've got a great panel that we put together with experts from all over the globe. We've got several folks in the US, and we've got two folks that are in Asia. So we've got some real good experts that can speak to this on both sides of the world. We're going to talk about what we know about the export control law to date, but first we want to step back and talk about how we got here. So we're going to begin the discussion with a little background on really some of the U.S. actions against China in recent months on the sanctions and export control side. Sally Peng is going to give us a perspective from Hong Kong and some of the sanctions and export control issues that are kind of circling around this issue there. And then we're going to talk about the export control law and how banks and other companies can best prepare themselves for this new law as it's implemented based on what we know now. So we'll be looking into our crystal ball and trying to give you our best efforts at how to help comply with this law when it actually is fully implemented and more regulations are rolled out. So to start off, I'd like to send it over to Andrew. Andrew, can you tell us a little bit about, kind of set the scene in the U.S. and some of the things that have been happening in the last few months?
Happy to, Adam. Happy to, and thanks for the introduction. I think you are right. The U.S.'s economic sanctions and trade program, as it relates to China and Hong Kong, really have escalated. Since June of this past year, and in the fall, there were several issues, several types of announcements that were made, and several implications. I think the first are the app bans, which commonly referred to as WeChat and TikTok, but there are other app bans that were announced on January 5th, and those app bans really initially started as an effort by the U.S. to essentially cut out certain companies that the U.S. suspected were sharing consumer information with the PRC government, and cut them out from the U.S. System. What's unique about these app bans? Well, initially the first ones were TikTok and WeChat. What was unique about those app bans is that authority for implementation and enforcement was provided to the U.S. Commerce Department, which typically has jurisdiction, as Rachel will note, going forward, on export control issues, and typically does not have jurisdiction over sanctions type programs. And these application bans provided them with certain rulemaking authority to determine what types of transactions are prohibited and what are not. Fortunately or unfortunately, those app bans have not gone into effect. There's been numerous litigation in the U.S., and those app bans have essentially been paused. And so it remains to be seen whether the U.S. government will pursue those further. The Biden administration is reassessing from top down all U.S. sanctions programs, including this one. And so, it'll be interesting to see if the U.S. continues to push for these various application bans, because they obviously implicate U.S. First Amendment and other types of exceptions under the International Emergency Economic Powers Act. So I think that's an interesting development there. I think one additional point following up on the app bans are the the new sanctions program referred to as Chinese military company sanctions. And those sanctions were announced in mid-November, and they were implemented on January 11th, and there are various dates depending on when a particular issue was added to the various lists that OFAC and the Department of Defense administers, which I think we'll touch on later. But the main point is that the U.S. Has taken a view that certain companies that it suspects to have an affiliation with the PRC military, the U.S. is interested in cutting those companies off from U.S. capital markets. And so these sanctions are really unprecedented because they target passive U.S. investors. The point being that U.S. investors cannot invest in foreign funds, such as mutual funds, ETFs, et cetera, that have holdings in these securities that the U.S. has determined to pose some sort of a national security threat. It's really one of the first times that the U.S. has impose restrictions on passive investors. They did so in other sanctions programs, such as Venezuela, but there was not the same degree of, the sanctions were not as strong in that context. And so there's been several developments from the fall till now, and there's been litigation regarding those developments that really will, determine the scope of these sanctions going forward.
Great, great. Thanks, Andrew. What kind of impact have those military sanctions had to date? I mean, kind of what's it like? What are you hearing from your clients about how that's really impacting them, particularly ones maybe at banks? I know that's just some really thorny issues, and OFAC's put out a lot of FAQs about how to deal with these ownership, kind of whether the 50% rule applies, et cetera, and kind of how do you envision maybe things changing in the new administration? I mean, part of the larger context here too is that so much of this was passed in the dying days of the Trump administration, and then we've got a new administration here that's really taking a look at everything.
Yeah, I think that they haven't been withdrawn under the new administration. They're still in effect. There are several securities that the sanctions go into effect March 9th and March 15th that were added during the Trump administration. And there's been a general license that's been amended and extended. And so it really remains to be seen if Biden will expand the sanctions. As of right now, it's been about a little over a month, and the Biden administration has not pulled back those securities. In terms of impact on U.S. investors, I think there's been a tremendous impact, not just on U.S. passive investors or even active investors. There's been a tremendous impact on non-U.S. hedge funds, non-U.S. other types of investment vehicles such as ETFs or mutual funds. And I think really the biggest challenge here is that non-U.S. persons, quote unquote, someone who has no nexus to the U.S. could potentially come within the scope of these sanctions to the extent they have U.S. investors in their funds, U.S. investors in various investment vehicles that they manage or advise under this theory of causing theory of liability. And so it has affected U.S. investors. It has affected non-U.S. investors that service U.S. investors. And I think that going forward, this could be a model that the U.S. uses in other contexts, potentially against other regimes. And just the last thing I would note is that under these sanctions, there's no concept of predominance. And so it's referred to as a Communist Chinese military company security. That's the securities that are covered, a CCMC security. To the extent one of those securities is in an ETF, and there's 1,000 other names in that ETF, the whole ETF is tainted. Whereas in other sanctions programs, such as Venezuela, such as others, to the extent that there's this concept of predominance where above a certain percentage of an ETF, it wouldn't take the whole ETF if there's a sanctioned security in it. And so it's really unprecedented approach that the U.S. is taking. So I think that's something that I would focus on to see if the Biden administration eases that particular restriction.
Okay, interesting. That's a great point that this might be a model for the future, and it's unfortunately it sounds like the headaches will continue for compliance departments trying to address this. Rachel, can turn it over to you and maybe talk a little bit about some of the other actions in the U.S. Kind of toward the end of the year, and particularly around kind of maybe some of the export control changes that have come about, and some other sanctions issues.
Thank you, Adam. Yes, it's great to speak with everybody today. And I'm going to take a step back, going first a couple of years ago when we first started to see this real ratcheting up of both U.S. sanctions and export controls targeted at China and Chinese actors, and also kind of the increasingly creative approach to U.S. export controls and sanctions in that space. We could start as early as April 2018, even, when the U.S. banned exports of ZTE products for 7 years. But really beginning in May 2019 is when we really started to see kind of this steady expansion in the application of various U.S. export controls to companies doing business in or involving China, and the extraterritorial reach of those regulations and laws in certain respects. This included developments both from the U.S. executive branch, so the Departments of Commerce and Treasury and the State Department, as well as Congress through some legislation that was passed to address issues involved in Hong Kong. Beginning on the export control side, in May 2019, the Commerce Department's Bureau of Industry and Security added Huawei and 68 of its affiliates to the US entity list. And this kind of began a string of actions of ever expanding regulatory actions against Huawei and its affiliates. So after the May 2019 additions, there was an additional round of additions of Huawei entities in August 2019. And then in May 2020, the Commerce Department proposed an interim final rule to add new controls that apply to foreign produced items where there was knowledge that it was destined for a Huawei entity on the list. That rule was expanded further when it was finally implemented in August 2020 to reach even deeper into the Huawei supply chain. It removed certain general licenses that had authorized exports in certain circumstances. It added 38 non-US Huawei affiliates to the list, and it restricted a range of actions by foreign entities. So these are companies outside of the United States where there was knowledge that the item that was being exported would be incorporated into or used in production or development of parts, components, equipment produced, purchased, or ordered by a Huawei entity. So that's really exceeding the boundaries of the United States, as well as really digging deeply into kind of a few layers down in a supply chain. So any instance in which a designated Huawei entity was a party to a transaction involving the foreign produced item as purchaser, intermediate consignee, ultimate consignee, really anywhere in the transaction, it raised these export controls restrictions. And this applied for a range of technologies that were specified or software subject to the EAR specified by the Commerce Department. Whether it was the technology itself was what led to the direct product, or if the technology created a plant, the major component of a plant where that major component was derived from the technology. So it really represented a broad extraterritorial reach of US export control laws, and that has led in part to the situation we find ourselves in now, where we've got kind of these competing jurisdictions of export controls. In parallel, the Commerce Department also expanded the scope of restrictions on exports to Chinese military end users and for military end uses. So prior to that point, there had been controls on exports destined for military end uses, but not end users. And so this kind of led to, and this happened around April of 2020, the expansion of efforts against Chinese military entities. And when this was initially rolled out, there wasn't a lot of clarity about what the US government was interpreting to be a Chinese military entity. There were a number of different lists and statements that had come up in different contexts, and there was a lot of confusion about what exactly this meant. In December of 2020, the Commerce Department Bureau of Industry and Security did publish a list naming over 100 Chinese companies as military end users. It's a bit confusing because we have now this list from the Commerce Department, as well as the separate Chinese military companies list from the Office of Foreign Assets Control, and an additional list by the Department of Defense in the context of the executive order that Andrew was talking about. So companies have a lot of kind of information, not necessarily conflicting, but certainly not consistent information about how and what the US government views to be a Chinese military company. So there remains some confusion for companies about how to apply all of this information in practice in their compliance programs, and a lot of an expanding scope of what the US government has interpreted to be a Chinese military company. In parallel with these actions on the export control side, we saw actions on the sanctions side, many related to the US response to the situation in Hong Kong. So in May 2020, the State Department first declared Hong Kong no longer warranted differential treatment under US law. So this had the effect of removing Hong Kong's special status in the export administration regulations, as well as other resulting effects. Then in July of 2020, on July 14th, we saw both an executive order issued by the Treasury Department providing a basis to block property of those contributing to the situation in Hong Kong. And on the same day, Congress passed the Hong Kong Autonomy Act. And the Hong Kong Autonomy Act required the State Department to publish a list of foreign persons that materially contributed to the situation in Hong Kong. So there was a lot of overlap between perhaps the scope of the executive order and the Hong Kong Autonomy Act report by the State Department. And then those individuals identified on the State Department's report were then subject to sanction under the Hong Kong Autonomy Act. Subsequent to the State Department's report, the Treasury Department was then required to issue its own report identifying foreign financial institutions that knowingly conducted significant transactions with the persons the State Department had identified. In October of 2020, State did issue its report. It identified individuals who had already been sanctioned under the executive order for Hong Kong, so the sanctions already applied. Financial institutions had been on notice, therefore, about those individuals, and as of yet, no foreign financial institutions have been identified in the Treasury's Hong Kong Autonomy Act report. So all of this goes to show kind of an increasingly complex and far-reaching network of US export controls requirements, as well as laws and regulations, really impacting a number of facets of transactions involving China.
Great, thank you. And it's probably a perfect jumping off point to transition over to Sally to talk about kind of her perspective being on the ground in Hong Kong and some of these issues. But I wanted to circle back real quick to something you mentioned in the beginning about the entity list, and just kind of, you know, how the use of the entity list has evolved, because you mentioned all of the different competing lists that companies have to worry about now with respect to China. But in the new export control law, there are also lists to be concerned about. So there's really a lot to kind of think about. And I think the US government's use of the entity list has evolved over the years, and it's become a much more powerful tool. And I'm wondering if you can speak a little bit to kind of how it's evolved.
Sure, yeah, no, we have seen the entity list being used to impact companies increasingly far away from the United States. So historically and initially, the entity list is, you know, a bar to exports or restrictions on exports to certain specified entities from the United States or those who are subject to US jurisdiction. The scope of what is subject to US jurisdiction is what has expanded so much in recent years, reaching not just those companies that are either in the United States or manufacturing products with diminished amounts of US origin content, or exporting products with US origin content, but also companies that are located outside of the United States using non-US materials and just basing their products on certain US technologies. So that's a real expansion of the reach of US export controls. And we've seen not just the kind of implementation of these regulations, but also the US Commerce Department has taken steps really to put companies on notice. Companies that are foreign companies doing exports solely outside of the United States, for example, have received letters letting them know your product is on our radar and potentially within the scope of these export control laws. So it's a real expansion of the scope, and also affirmative steps taken by the Commerce Department to implement these regulations. Now, under the current administration, as Andrew mentioned, it remains to be seen exactly what approach the Biden administration will take. We haven't seen anything to indicate a rolling back of the entity list or the foreign produced direct products rule, but it's certainly possible that the Biden administration will adjust its approach going forward and also adjust its enforcement priorities as they evaluate their China policy.
Okay, great, thank you. Sally, can I turn it over to you to give us a perspective from Hong Kong?
Sure, thank you, and I really appreciate that, Adam. How you frame the questions, and really a lot of times people are focusing on China, focusing on Hong Kong, but isn't it all a part of a reaction to a lot of action that being done in U.S. government? So this is being done set up perfectly, and then particularly to Rachel and Andrew, both of the measures that you mentioned really largely, we live on almost on a daily basis, and then every day you wake up with a lot of different information and people calling you about all kinds of information. A lot of times it really needed clarity. So because Rachel has gone into really good, really good coverage of Hong Kong. So I think what I want to do perhaps, because starting with July, then with the Hong Kong autonomy law, with the 11 Hong Kong and China officials being put on the list, it's actually put many of us, like Adam's on the ground trying to do business, and a lot of us are American. How do we do business in Hong Kong? So and also I think particularly from the FI perspective, they really worry about secondary. If you're not American bank, you're worried about secondary sanction as well, and then it was a real threat. And so of course all the banks and all the MNC, you see them trying to get as much information as they can, trying to upgrade their screening protocol, trying to do the gap to gap, like an end-to-end type of gap analysis, and then also calling your lawyers, calling your suppliers, and about all these kind of things. But I thought that one of the things that as a business group here in Hong Kong, we're all part of American Chamber here in Hong Kong, because all these things are all coming so fast and from so many different organizations. So we decided to, under the banner, not under any individual company, under the banner of Hong Kong, American Chamber of Hong Kong, we actually had a chance to have a few calls with officers from OFAC, from state, from BIS, under the Chatham House rules, of course. So one of the things that I want to share is that we first start telling them that, do you understand how small uptown Hong Kong is, that you can really run into the people that you just put them on sanction list? How do we deal with that? And then obviously for some of you guys are familiar with Hong Kong, the people who they put on the sanction list oftentimes are we call the sponsor of this club, that university, which we all have doing business to. And most directly, probably give you one example, is that every year American Chamber actually hosts a Thanksgiving dinner with all the people that they put on sanction list. So we first and foremost question, are we still allowed to have that Thanksgiving dinner? They didn't answer that question, and also that question had become not relevant because everything is canceled, so nobody's get to have any kind of Thanksgiving dinner. But that question remained to be answered, and it also tells you that how difficult it gets, and it will get if things are not rolling back, that American business is trying to do business in Hong Kong. And then there's also another things about how we advise company, particularly FI, to do their own screening issues, because a lot of the screening that Rachel mentioned, it's coming from all kinds of different lists. What kind of lists? It has bears different type of ramifications. And one of the lists, particularly of the list, has a lot of Chinese character in it, because it's not just English, it's not just translation. You also need a lot of people that can be doing this work. So we certainly become very popular. We are being asked to do a lot of secondment, but we can't keep seconding people to different places. So we won't have our own team anymore. And so it's become quite challenging when it comes to just trying to in compliance with all these ever-changing rules. On the Hong Kong export control side, just as what Rachel alluded to, because Hong Kong basically first they suspended all the possible exemption that Hong Kong can use, which used largely by universities when they need to do research. So they don't get to do that anymore. For quite a few companies, US company, they have data center in Hong Kong. Of course, it's not going to be that easy anymore. If anything, they have to go through a decommission of their data center right away. And then it comes on full circle, I think on December, right before Christmas, that BIS issue a final ruling final rules basically remove Hong Kong altogether. So like if you now look at BIS rules, you don't see Hong Kong as a separate destination anymore. You can't say that I'm shipping goods to Hong Kong. It has to go to China. And then there's also, for some of you familiar with all these entity lists, you used to have a separate Hong Kong entity list, not anymore. Everything is merged into China list. So we're officially that Hong Kong is being treated as the same country group D as China. It just turns on a lot of restriction, a lot of things you need to get licensed on. There, and also I think probably the biggest expansion will be the MEU. It used to be shipping to China, but then now if you ship to Hong Kong, you also need to do the MEU screening as well. And the same thing, related to the foreign direct rules. So all these things already making, so Hong Kong in the last 2 years, I would say, has been quite difficult when it comes to almost everything like daily life. So it's making doing business in Hong Kong even more so. And there's a lot, and Hong Kong, for a lot of people who probably don't pay too much attention, that Hong Kong has its own strategic goods, dual usage goods control system, which is quite strong as well. So we've over the last couple of years, we've been advising clients that not only you have to follow the US rule, you also have to follow local Hong Kong rules. A lot of times, the best thing about Hong Kong that the goods already arrived because it takes a few hours on the plane, but they forgot to apply license. And then when you remember, so, oh God, I forgot to apply this, and I need to send it back. You can't because it already arrived. In order to send it back, you need another license. You need an export license. So basically, you're getting hit on two violation at the same time, just on one particular item. So Hong Kong has this challenge, and on top of that, with all the U.S. New regulatory, really putting Hong Kong business, U.S. business or U.S. interest in Hong Kong quite challenging. So that's a part on the Hong Kong side. I can pause for 1 second before I move to the China export control up to Adam.
Yeah, no, I just had a question. Thank you. That was it's great. It's you and Rachel, the perspective on Hong Kong is fantastic. So thank you. I guess I'm wondering, folks on the line are probably wondering as well. Just how are you advising kind of clients practically on how you assess exposure and plan, or maybe what are some of the things that you're seeing that companies are doing that you think are really cutting edge or forward leaning in this area, because it really is. I mean, in the last couple of years, as you said, things have been really getting more and more difficult in Hong Kong, and then the pressure from the U.S. government and others has just risen the temperature as well. How do you advise on this?
So I think for most FI that we deal with, they already have a pretty good screening system. And what they need to do is someone giving them good information, and then so that they can upgrade their current screening system. But we also run into a lot of company that got caught in the supply chain, let me put it this way. So some of the lists that some of the industry that Rachel mentioned are the new type of companies that really need a compliance program. And surprisingly, at least to me, sometimes when I talk to their compliance program, they largely remain non-existent, meaning that they will let their supplier or their customer to dictate their compliance program. For example, you will find some semiconductor company, they're saying, oh, I don't have to do MEU because that I should have, my customer will do the MEU, or that my supplier, the end supplier in China should be doing that. And then we oftentimes really need to get them to understand that's never a good answer when BIS come knocking, or when they come. In regional, we work here very closely with regional ECOs. That's a BIS officer based in Hong Kong, Beijing, and as well as in Singapore. They do a lot of end-use check. They oftentimes share the same story, some war story with us, as well as that they have a lot of companies have absolutely no idea that it's their liability and it's their responsibility to do that. So we're seeing both ends of type of compliance needs.
Great, thank you. Yeah, why don't you and Chee Seng kind of take us through the new export control law? Very curious to kind of hear about what's known and what is unknown with that law. Chee Seng, I think you're on mute.
Chee Seng, you're on mute.
Okay, Let me share the screen. Okay. Yep. So can you all see that?
Yes, we can.
Okay. So I think a lot of people talk about this, the new Chinese, the China's export control law. Actually, this new China export control law has taken effect on 1st December 2020. So in actual fact, it regulates the export of sensitive materials and technology from China to overseas. Okay. Now, the issue is that when talk about these sensitive materials or technology, now, I think this is also very tough for the bankers because when you look at it, how do you know whether the materials export out from China to overseas are very sensitive, especially like country like Singapore. We are a trade finance center. So we are dealing with so many different countries, US, China, or even Middle East or Europe. Then for the bankers, must they know that item they handle, especially for those materials, whether sensitive or not? It's very difficult to say. So say, for example, like, of course, over here, later on, I will go into the details. What are the control items, maybe? Now, of course, not only that, this export control law also extends the Chinese jurisdiction even beyond the national territory by providing penalties and obligations binding on importers, end users, and more. Say, for example, if let's say a Singaporean company imports certain items, and actually it is in violation of the China export control law, then in that case, even though the importer is a Singaporean company, but it could also be punished under the law. So this is actually happened in the past, not just only Chinese, not just only China. Say, for example, many years ago, it happened. I think one Singaporean company imported some sensitive computer device from the United States, and subsequently, this material or this device used by the terrorists in Iraq. So I think some of the American soldiers there killed. So because of that, the SBI investigate, and they found out this material all imported by the Singaporean company. So subsequently, the directors of this Singaporean company arrested. So two of them sent to US for trial. So this what happened. So not just only the China export control law, and of course in other countries also have the similar control. Now, so actually, what are the items? Dual use items. And talk about dual use item for bankers. How much do you know about the items you are dealing with? Say, for example, I was told by some of the customer, this oil pipe or water pipe export from, that can be from China or can be from any countries to Middle East. And end up, the terrorists over there convert the pipe into cannon. So this what happened. So this can be classified as so-called dual use item, but how do we know? So this is also quite important for bankers. So I would say for banks now it's very tough, not easy to work in a bank, especially for trade finance area. Then military products, I think this is very clear-cut military items. Then nuclear, so these are also the control items. And technology, the services and items related to the maintenance of national security or national interests. So all these are so-called control items. Then who are the parties? Of course, the exporter from China. Then not only that, the intermediary trade service provider, say for example, like the logistic or financial services provider. Financial services provider, of course, involve banks because you are the one who finance the transaction. Then, of course, the importers and the end user, these are the parties can be in problem. So the consequence of this so-called violation, the fines can be up to 20 times of the amount involved or 5 million RMB. Okay, then confiscation of the illegal income, and revocation of export permit. Okay, not only that, for the corporate, the new export permit will not be granted within 5 years. Or for individuals, say for example, the executive or other directly responsible personnel can be whole life. They can't get any export permit. So this is quite serious. So in that case, in order to comply with this, then of course, especially for bank, traders also have to know. Must ensure that the items are not within the control list. Then if you are not so sure about that, they have to consult with the authorities or perhaps a professional advisor. Then of course, same as the AML guideline, the bank have to do due diligence check, but of course not only the bank, the traders. Like today I received an email from my counterpart in Europe. They received LC end out problem because there's no shipment, that's shipment, but end out, the so-called issuing bank is actually not a bank. And not only that, no payment at all. So the issue is that because it never done a so-called due diligence check. This is one of the so-called fraudulent transaction. But of course, for those any other area, for banks, for traders, you must always ensure that you have done due diligence check before you enter into any transaction. Then not only that, have to revise the template contracts by adding the so-called export control compliance provisions. And of course, pay attention to the changes and also provide routine training. These are very important. Like recently, say for example, for banks, because I was a banker before, I always stand in the position of the bank and look at the issue. Say for example, like recent, suddenly China banned import of this pineapple from Taiwan. I can't imagine if, let's say, the Chinese importer have applied for an LC in favor of the Taiwanese exporter, and the LC have been confirmed by a bank in Taiwan, but as the pineapple had not been shipped yet. So the beneficiary issue is that, can they still ship? If they ship, will they be able to get the money? They will still get, because the LC is confirmed by a bank in Taiwan. So the confirming bank will get into trouble. So end up documents sent to the issuing bank. Issuing bank still have to honor because bank do with documents. But the trouble is, for the importer, they may not be able to get items because bank. So this is a problem. So for banks and for the traders, you have to observe all these law carefully. This is my comments. Okay.
Thank you. Sally, do you want to, I think you're
Yeah,
on
I
mute.
just wanted to add, I thought those are great observation and very practical advice. I want to add maybe a few things that a little bit more touch upon FI, is that, so first of all, I know that the China export control law in effect in December 2020, but in my life, we have been tracking it for quite a few years. So this kind of goes back to what Adam just said, that a lot of a reaction or the measure taken by Chinese government really is in reaction of the U.S. government, because for the last 4 years, every couple of months we hear that the Chinese the export control law is coming, and probably coming next week, probably coming in a month or so, but it never did until October, then goes in December. So it's a long time of preparation and anticipation of the export control law. There are a couple things that we in terms of, if I do compare contrast with the U.S. Type of export control law or EU-based export control law, they're very similar in the sense that they have one central authorization. They haven't figured out yet. So as most of you know, in China, you have to wait for the detailed implementation law comes out. So they haven't figured out yet. It's just called, like, a few agencies put together as we call state export control authority. And then the control item really is a list based, so you have all kinds of different military products, dual use products. However, there's certain things I thought that it caught my attention is the focusing on data, such as technical documents, that not specifically mentioned. And then for this particular law, it has gone through at least 3 drafts that are published. And the technical data part of it, as part of the restriction, was in the first draft, and it disappeared in the second draft. Everybody was like, "Oh, very relief," but then showed up at the final draft. So it shows that this is an area that is also heavily debated, behind the background by the Chinese officials, whether they want to include that as well. It's not specifically said, but what is the technical data? But most of us, at least probably this side of the world, thinking that includes at least source code, algorithm, and other data. And we know that is because their language was put in the middle of the draft, and it was disappeared, and then toward the end of the final draft. There is also, like what Chee Seng said, it has a ding export control element. It has the extraterritorial element as well. What I find it different, which probably the first time I read something about this, is that the exporter actually has obligation to report, even though the product that may not be on any of the list. So this is what's for exporter, that they know or ought to know that this will affect, their action will affect the national security, and the government encouraged to check in with them in order to figure out whether that's a violation of law or not. And at the end of the text, again, it's the same thing. There's a reciprocity and retaliation from the China export control law. And that was in and out of text as well. So this is also one area that I think that heavily debated in the background. And for FI, there's certain things I think you should be particularly aware, is that in the language it says during the investigation, the authority actually, they're very powerful. They always have been very powerful, but in particular related to export control law, it says that they're allowed to ask bank account, bank records, all the data and custom records, not just on the exporter, also on the people that they investigated. So it could be that you're trying to exporting something that Chee Seng also said, but then they're investigating the entire parameter. So then they could ask the bank data of other people as well. So I thought that was one area that I would be on the lookout to when it comes to new when there's a detailed implementation rule comes out.
Great. That's interesting. I guess you've teed up my question to you. When do you think there will be more clarity? I mean, do you have any sense? I'm reading everything I can, but I guess kind of, does anybody have a sense? So
I practiced a long time in custom law as well. If I look at some of the China custom rules, and then whenever we call the mother rule comes out, the sons and daughter rule will probably come out within 8 months to 12 months. But that's on the custom side. The reason I think it's very, very not likely to be predicted is because this is so political charge that it could be set. I believe that there is an implementation rules already written, but they're just holding on it. Just like a lot of times we notice that China government holding on to a lot of different rules, different measure, and then they really just throw it out when they see something coming. So I think that we're in the, how do you describe, eye of storm, or something is coming type of thing. A lot of us on this side, we're just hoping that perhaps, or wishing that the new administration will really roll back something. But then, like I said, we also had a section with the new administration. We were told it's very unlikely, and then if anything, that they are focusing on human rights. So it's going to be a tough time. That's what they were telling us too.
Right. One other follow-up, and I don't want to take time away from if the other panelists have questions, but I have you, Sally. There's some other things going on in China that are kind of around the export control law. I mean, we talked a lot about lists and the different lists. There's, there are, lists within this export control law, but then there's an unreliable entity list.
Right.
What kind of, how does that play into this law? What's different about it?
It is different. That's a great question. Unreliable list, if you look at the implication, is that when it comes to export control law, exporter, you will lose the privilege of exporting for 5 years or possibly permanently. And then there will also carry the penalties and criminal offense as well. But if it's on the unreliable list, it's not just exporting privilege. It's that you're not allowed to invest anymore. You're not to do a lot of activity in China. So that's much larger and can be used even more creatively, let me put it that way.
Got it. Thank you. Any other panelists? Do you all have any questions of Sally and Chee Seng about this law?
I had one question, Adam, maybe not a question, more of a point. The point, Sally, you were making about reporting obligations, oftentimes under US sanctions and export control laws, that can be, an unknown and oftentimes inadvertent violation of law. So for example, OFAC has a reporting requirement for rejected transactions. So if you reject a transaction because it could implicate US sanctions, you're required to report that. And many people don't quite know that, and the reporting obligations were expanded. And same with the U.S. anti-boycott laws, which are administered by the Commerce Department, have the same obligation to report even requests to comply with an unsanctioned boycott or an impermissible boycott. And so, oftentimes, I advise clients that yes, make sure you're not doing business with bad people, but you also have to be on top of situations where you have a reporting obligation, because last thing you want is an inadvertent, footfall violation of something where you actually did the right thing.
Right. Interesting. We do want to leave some time for questions here at the end, and some are coming through in the Q&A. So just encourage everybody in this webinar to please send through any questions you have in the Q&A or in the chat, and we can answer them as they come along. I think some of these are easier to answer live than typed. Rachel, there's one for you, and let me read it out. Can Rachel provide an example of the expanded scope of export regs, i.e. an example where the non-US origin products that are based on US products?
Sure, and that's a great question. These expanded regulations have really been focused on targeting the semiconductor industry, and the technologies that are identified as subject to controls are software and technology that are used for developing semiconductors. So it's the tools and the software and the technology, as well as the semiconductors themselves. And the rule in particular applies if there's knowledge that the component or part will then be incorporated into an item for Huawei, or for which Huawei is somewhere in the transaction. And willful ignorance is not an excuse. So you can't just purposefully not find out where your item is going when there's a real risk that it might end up with a designated entity. And so just to give a real world example, and then I'd be interested in Sally's thoughts in particular on how this sort of example might intersect then with the Chinese unreliable entity list regime or another regime. So for example, if you have a Chinese company that is involved in the semiconductor manufacturing space, and they're manufacturing items that are originally based on the controlled US technology, and just taking a step back, a lot of this technology was developed, by Texas Instruments, by the United States, decades ago. And so the technology that is essentially used worldwide in this space is potentially within the scope of these expanded US export controls because of the history of its development. And so if there's a Chinese company that's developing these products for export or incorporation into a Huawei item, then they're within the scope of this US law, but they're also within the scope of the Chinese legal regime. And there are also rules in China against complying with these US restrictive measures. So I would be interested in Sally's perspective on the risks a company in China that would potentially be subject to these US export control laws might have with complying with these laws. And just before I turn it over, I would also flag that I completely agree that these issues are not going away anytime soon. The Biden administration has announced a review of 4 technology-related supply chains, and the semiconductor supply chain is at the top of the list for that review. So they're really focused on the semiconductor industry from a US national security perspective, and I expect, if anything, they'll be kind of expanding the scope of restricted measures in that space in an effort to protect the US semiconductor supply. But Sally, I'm interested in your thoughts on what happens to a company in that situation.
So I don't want to single out semiconductor because there are only a few companies that they're in one particular region, one country. But
we can make it a broader hypo.
Yes,
that's easier
because it's so easy to guess.
Right.
So right now, I think that I think if I look at some of the even semiconductor or banking, because the banking industry, FIs also get caught in between. where U.S. sanction asked them to do certain things, but then the day after, Hong Kong Monetary Authority, Hong Kong MA, is the one that in charge of all the Hong Kong bank, telling them specifically in press release and on the news, telling them that you do not have to follow what they call unilateral resection. So it really, there is a conflict law here and there. And then same thing to individual like me, I can follow certain rules in Hong Kong as a US person, but on the other hand, that the national security law, I think it's 29, I was told to remember that, also tells me that I shouldn't be following those rules, because then that will be in violation of an NSL 29. So all these things are happening. So I think that when we look at particularly on the product size, we do want the company go back to the basic, look at very closely of your product. Did you even get the classification right? Using MEU, for example, there's only certain scope of product that's subject to MEU rules. But some clients, they will think that, oh, everything's subject. So that's like a few times we see over compliance. After you figure out the rules, then look at your supply chain to see where whether you have prepared those documentation. A lot of company, they overconfident thinking that they already calculate those regions, the origins, but it's actually not true. Once we do a few test runs, so it's not true. Another thing that they've really been doing and has been doing for the last few years for these companies that caught in between supply chain is diversify their supply chain. So you see Japan is coming to play, Vietnam is coming to play, and all these different products. A lot of places that they really need to do that. But I would be, I need to be honest here, is because I don't see that room much for these companies anymore. If you can see what Rachel has alluded to, the new Biden CEO of the reviewing. The reviewing is a verb, meaning that it's telling these companies that you need to pick a side. You can't diversify your supply chain anymore. You can't just keep some production for the China market. Like we have, in the supply chain world, we oftentimes have China for China strategy versus non-China strategy. The room of that is getting less and less narrower. So for a lot of companies, they're coming down to the decision whether they need to side with one particular countries for the next 10 years, when two countries are in competition of everything, not just in competition of just talk. They're in competition of human resource, the materials, the technology and talents, for that matter.
Yeah, and we're seeing that, across the board, not just in supply chain space, but kind of, this leads us to the sorts of conflicts of law issues that are kind of rife throughout all of these areas. And, historically, we've dealt with those sorts of issues in the European sanction space with European blocking statutes against U.S. actions involving Cuba and Iran. And now in China, companies are facing the same sorts of issues. So we have companies essentially and financial institutions as well in the position of needing to really balance risks of complying with the Hong Kong Autonomy Act, complying with U.S. export controls requirements versus the risks of operating in China and the national security law and the requirements that imposes. So it's a real fact-specific analysis and certainly not an easy place for companies to be in.
Great, thanks. We're just about at time, but there are a couple other questions that came through on the Q&A. So if folks can hang on for a second, let's just try to get through these real quickly. Question, I'm not sure who this is to. Is it possible to insert the controlled items of new control law, HS code, in SWIFT format? I'm not sure who'd be best placed to answer this. I guess a question around some of the new controlled items that are going to come out in the new Chinese export control law. Is it possible to put them into a SWIFT message format? I'm not sure. I suppose. Go ahead, Chee Seng.
I think it is quite unlikely because I think it's very tough, because who knows? I think it's not easy. This question is not easy to answer, but I think it's quite unlikely.
Got it. Okay.
Yeah, especially because, as we know, SWIFT takes 3 years to roll out updates to their field. So there'll probably be lots of changes by the time it can happen.
Yeah.
Of course. And then one final question, and this is my question is to Sally Peng. Sally, very popular today, but I think it'll be a Sally and a Andrew, Rachel combined response. Can we regard China's export control law similar to the United States' Trading with the Enemy Act?
That's question I never gotten. So I thought that I want to circle back for Andrew to answer that question, but I thought that Rachel pointed out a really good, interesting observation is that when China put out their blocking statute, even in the press release, I mean, we know blocking statute happened in US and also in EU, but in the China side, they actually specifically refer to EU blocking statute as if that's how they model after. And I do get a question about, so when Chinese reading through those things, the first thing they see is compensation. Like, can you get compensation? Can you really get compensation from the rule? So I'm going to let Andrew answer that.
Yeah, I mean, it's hard to compare the China export control statute or the blocking statute is just one of the many statutes that underlie
Right.
sanctions. I mean, there's several that do, so I'm not going to try to compare them. But the thing I would close with is I think the theme of 2021 will be conflict of laws. To follow up on Sally and Rachel, that is something I deal with on a weekly basis with clients. So I think that will be the theme over the next few years.
Great, thank you. Well, thank you to all the panelists. Michael,
sorry,
I'll turn it
Adam,
over to
we
you.
got one other question through email. If everybody has just another second, I'll toss it out. You may not be able to answer it completely, but I just wanted to read it off. So this comes from a retired senior international banker. The Belt and Road Initiative, the BRI, has not realized its intended success level for various reasons, which is, of course, beyond the discussion here. But he thinks it appears that the export control law may provide further bureaucratic challenges to the BRI related exports as government assessment is required pre-export. Items critical to BRI as international obligation, type of export, destination countries and regions, and then users all seem particularly vulnerable to being impeded or somewhat delayed. What are the thoughts of the panel on the potential for impact of BRI exports of the ECL? Quiet. Crickets. I appreciate that this is complicated and everybody wants to be careful how they answer.
It's a really good question. And then also remind me, there's a sanction against the One Belt, One Road. It's the South China Sea type of development. So I think that's probably a really good question for, I'm hoping, and then thinking that probably the Biden administration is currently thinking as well, because when they think about export control, is it really part of the extension of the diplomatic power and struggle in South Asia as well. And we see that every day. I mean, we deal with India type of export control, and then several export control of South Asia countries all rolling out at the same time. So I think that you are seeing this these geopolitical conflicts in this particular region, and in particular, in One Belt, One Road, it's going to be the main thing that under the RCEP, because everybody knows that there is a new trade agreement under RCEP. So that is something that China is going to push. Also, there's a new terms called like a double circulation. Like they need to have a circulation for Chinese economy to be grow. They need to be exporting and also in domestic market as well. So you're seeing all these same type of thought process come together for China to continue pushing One Belt, One Road initiative, and with the strategic alliance of a few countries that are still quite close to them. So I think there will be more of that.
And I do think, from the Biden administration, we're already seeing more of a multilateral approach to most issues, as well as a somewhat more nuanced approach to export control, sanctions, and foreign policy in general. And I expect that to apply here as well. And I wouldn't be surprised if we see engagement in situations where that didn't happen under the last administration. And so, I think going forward in general, we might see opportunities for coordination that weren't around before, although I don't expect anything groundbreaking anytime soon.
Perfect. Excellent. Well, then Adam, if you want to say anything else, I can, whenever you're done, I can step in and wrap everything up.
No, thank you to our panelists. Thank you for the interesting discussion. I think this is an important discussion, an important new law, and you gave great context and great background. So thank you. I hope it was very informative for our web participants. I just want to mention, Michael, I want to cut you off and mention that Chee Seng's slide deck. Thank you very much. He's graciously agreed to provide that to participants. So Michael, I think you'll be able to distribute that to them, and thank you, everyone.
Perfect, excellent. And I also thank you, thank all the panelists for participating. This really has been an informative, really just an excellent session. I thank all the attendees for joining us. I will follow up with everyone later today with an email that'll outline how to get CPD points, and we'll provide a link to for everyone to be able to download Chee Seng's presentation. It'll also give you a chance to send me any follow-up questions. I'm happy to send them out to the panelists as well and see if they can answer them post-event. As I said, this has also been recorded, so my email will also show you where you can, where you can go to watch the recording. So with that, I thank everybody for joining us. I realize we ran about 7 minutes over, but this has been such a great discussion. I don't think anybody minded. So I thank you all so much for this. Thank you for joining us, and thank you panelists again. And we look forward to seeing you all at the next session. Stay safe, everyone, and take care.
Thank you.
Okay, thank you. Stay safe.
Thank you.